Welcome to the Sui Generis Show, your unique perspective on everything related to your civil rights and the criminal injustice system. With Erica Merrill, I'm attorney Brian Jones, criminal defense and civil rights warrior. Today in segment 1, we'll be discussing 3 incidents of bad behavior by police officers. 31 guards in New Jersey were suspended after a trans woman was beaten severely by guards at the prison. Second, several officers were suspended or placed on leave for their role in handcuffing and pepper spraying a 9-year-old girl who was experiencing a mental health crisis. And former Columbus police officer Adam Coy was indicted and arraigned on 4 charges, including the murder of Andre Hill. In segment 2, as promised, we'll be exploring our holistic approach to pre-indictment sexual assault allegations defense. You don't have to wait until you are charged to hire a lawyer. And answering and addressing accusations of sexual misconduct early on in the process is critically important. I'll tell you why you should get on your defense early in the process when you're falsely accused of sexual misconduct. To make sure you don't miss an episode, subscribe on Apple Podcasts, Spotify, and YouTube, and follow all of our social media channels. Look to the lawofficeofbrianjones.com for everything you need to know about your civil rights and the criminal injustice system. Erica, did you see in the news this week 31 guards suspended at New Jersey's women's prison plagued by sexual violence?
Wow, that is amazing. I have not heard of anything like this happening. What were the events that led to such a large suspension of prison staff?
A 24-year-old female trans inmate was handcuffed and beaten so badly by 4 guards that ligaments ripped in her knee, and she is now confined to a wheelchair. This incident allegedly occurred during a forced cell extraction, which is every bit as violent as you might think that name implies. The prison's top administrator, 22 correctional officers, 11 male and 11 female, and 9 supervisors have all been suspended. The New Jersey Attorney General is investigating this case, and the governor has appointed a comptroller to lead a separate and independent inquiry into the incidents. The state assembly has announced hearings into the, quote, widespread abuse and use of force at this particular institution. Now, this institution has a long and sordid history of abuse of inmates and was subject to a 2020 Department of Justice report that found that inmates were regularly sexually assaulted by guards at this all-female prison. Coercion was deemed so prevalent that it was found to violate the constitutional protections from cruel and unusual punishment. And you'll remember from our prior episodes how difficult it is to meet that standard in an institution.
Yeah, no, I mean, absolutely. And I mean, it sounds like there were a lot of things going on that they didn't know about. What are the protections that are offered to an LGBTQ individual serving a prison sentence?
So the Prison Rape Elimination Act addresses the detection, prevention, and response to prison sexual assault. This law led to the national standards to prevent, detect, and respond to prison rape in 2012. Now, the standards that directly apply to prisons and jails require them to pay special attention to protecting LGBTQ individuals and those that are gender nonconforming or intersex. And it provides incentives for compliance. So this isn't just a stick situation, Erica. This is a carrot as well. But there are, of course, penalties for noncompliance. What the federal government has tried to do in the last 20 years is really reduce the incidence of sexual violence in institutions. It creates a moral conundrum for prisons, places where people are supposed to be rehabilitated and taught not to behave in an antisocial manner, are rife with antisocial behavior, violence, and sexual assault. Now, the same prisoners' rights that we've discussed on our show, including the right to be safe and the right to be free from cruel and unusual punishment, have been enacted in this situation. the right to privacy, the right to free expression and religion, the right to necessary medical care, and the right to equal access to all the things that are necessary to survive in these locations. Now, it really depends on the location and the facility, the state and local ordinances that are used to actually enforce these federal regulations, as to whether people have appropriate protections and whether their rights and their safety is protected in these institutions. And obviously, this prison in New Jersey, Erica, is doing a terrible job of meeting those standards.
I mean, the story is just heartbreaking for that transgendered woman. How can a family member of an LGBTQ inmate help their loved one stay safe? Are there actions that they can take from the outside?
There's a variety of actions, and most of these actions can be taken on by the family members themselves, but oftentimes people will retain our services because of the relentless nature with which you have to go after these institutions. So, first and foremost, medical advocacy. The right to necessary medical care is a key component to receiving the supportive care that gender counseling and transitioning individuals need. Coordination with medical specialists and ensuring the proper medication is really important to creating an administrative record for protection area requests. Now, you may recall the notable case of Chelsea Manning, the pardoned former military prisoner. Now, her counsel led a groundbreaking and successful effort to provide her with the necessary treatment and medications to complete her transition while she was in custody. Now, this framework has been repeated and replicated across the country in state and federal institutions. Safety is a completely separate issue, though, Erica. The best tactic to ensure that your loved one is safe is to make sure that they're aware of their rights, and this is where an attorney can really come in handy. Sending a formal letter through legal mail so that that letter gets to your loved one in the institution and explains to them what their rights are and how to exercise those rights within the prison administrative system. Any chance for a civil lawsuit to protect them if things go that far depends on the exhaustion of those administrative remedies at the outset and making sure that they're properly educated about what those administrative remedies are is critically important.
Oh, I mean, I agree, and I'm really glad that they have help if they want it. I mean, I feel like having the right attorney looking at the case and making sure that they are treated appropriately. We've spoken about this before in past interviews where, even if someone's just in lockup waiting to be tried, they haven't even been convicted of anything yet. They haven't even seen a judge yet. They could be treated poorly. It's very helpful to have someone who knows the ins and outs of the laws that are going to protect your rights while you're waiting to be heard.
Well, and that's absolutely true, Erica. It's getting involved, it's staying active about the process that can be most helpful. Time and time again, what we've found in our practice is that once we get involved in the situation and our client knows what his or her rights are, and they start using those administrative remedies, the prison kind of gets the picture and starts complying with the law. And that's what we're ultimately looking for. We're looking for protection. We're not looking for money. Speaking of people that are going to be needing a lawyer and looking for protection, Erica, did you see in the news this week a police officer has been suspended and is facing a criminal investigation after pepper spraying a 9-year-old girl who was handcuffed?
I mean, this is one of the worst stories I think I've heard. Uh, we were discussing it a little bit before we started the interview. Can you give us some insights to what happened in this case?
So we don't have the officer's name yet, which is once again an example of the police getting a benefit that regular citizens don't get and having their name splashed across the media and trashed in the public courts. But the deputy chief of police described this situation as an alleged suicidal child who was making threats of harm against herself and against her mother. Now, the city's crisis intervention service wasn't called to the scene, and that was because of a judgment call made by a dispatcher. The body cam video in this case reveals that the child was repeatedly crying out for her father as officers struggled to get her into their cruiser. One officer actually accused her of acting like a child, to which she responded appropriately, "I am a child." The officers chose to pepper spray her in the face and then close the door on her as she's crying and asked to have her eyes wiped out. This is, remember, a 9-year-old child who has now been pepper sprayed because she wasn't voluntarily being arrested and hauled away from her family while she was in the middle of a mental health crisis in which she was suicidal. Now, as a father, witnessing my child's distress, I would be heartbroken. And this particular child's distress and terrible ordeal really, it just really saddened me and angered me because police are really supposed to behave better. You've been given a badge and you've been given privileges that the average citizen doesn't have, and we expect better of you. This child needed qualified medical personnel and instead received violent abuse at the hands of the people who are supposed to be protecting her.
I mean, I'm just astonished by this story. I mean, we usually tell pretty terrible stories about the police treating adults badly and Black people badly and women badly, shooting people by mistake, shooting people when they have their cell phone. But we have never spoken about the police treating a child like an adult and pepper spraying them when they're difficult. I mean, these are grown men handling a 9-year-old girl. I have cannot fathom why they would have done that. So,
She maybe overpowered them. I don't know. It's tragic.
so we've talked a little bit about some of the alternatives. What we'd like to see happening in the future instead of just calling out the brute force of the police when there's a mental health situation where maybe someone else can help. Can you go over what those alternatives are and remind us again what we'd like to see in the future if something like this happens?
This shines a light on the tragedy that is the lack of civics education that most Americans have. Uh, Most people think the only option in these sorts of situations is to call 911, but the reality is very different. The National Alliance on Mental Illness, also known as NAMI, exists and can send a crisis intervention team to assist you. Here in Ohio, we've got the Ohio Department of Mental Health and Addiction Services, the Ohio Suicide Prevention Foundation. And there are a variety of other statewide organizations that have networks of local resources that are available to come to your home or assist as they can by phone. If you go to onoursleeves.org, you can find a whole page for resources in your particular area. Now, a response by a qualified medical professional or a licensed social worker or a counselor is key to the successful intervention in these mental health crisis situations. And it's shown by the research to save lives. There was just a story this past weekend about a crisis intervention team in Denver, Colorado, that consists of 3 individuals, and they're unarmed, and they have not arrested a single person in the entire year that they've been in existence. And they've been out on hundreds of calls. So what we see here is the opportunity to actually help people rather than arrest and prosecute them. Erica, there must be a societal shift in perspective in asking the public to respond to mental health crisis, not by calling law enforcement, but rather taking the time and using our best opportunities by funding local mental health services, advocating for the presence of social workers or medical response team individuals, and a mental health crisis intervention team to these scenes rather than law enforcement officers. They're just not properly equipped to handle this sort of situation.
I mean, yeah, obviously they look at a 9-year-old child and they treat her like an adult. I mean, it's really pretty scary. Now, I would hope that there are going to be some repercussions for this. What What recourse does the family of this child have to help her with the trauma of this experience?
Well, for once, things have kind of gone well in this area. The authorities are just as outraged as the public, and an investigation is underway. Depending on the results of the investigation, the officers might be criminally charged for their assault on this child. The child is entitled to victim services support for the assault, including restitution for any counseling and any other treatment that she requires. And depending on what the response from the government is, she may or may not need to file a Section 42 1983 action to receive compensation for the harm that these officers have caused her. Hopefully, the jurisdiction, the local authorities will do the right thing and agree to that settlement without putting this child through the trauma of a lawsuit.
I wish the best to the child and her family, that she can get the help that she needs. I mean, that is such a young age. I mean, not even a pre. She's not even really close to being a preteen. No double digits yet. So, I mean, I know that there's a way to turn things around for her, and hopefully they can get her the help she needs.
I agree, Erica. And speaking of people who need help, did you see in the news this week that Columbus police officer Adam Coy was arraigned on 4 charges, including murder, and received a $3 million bond?
And I did, and it's just like the whole situation is pretty surprising. Can you walk us through what happened to get Mr. Coy in so much trouble?
So Adam Coy responded to a call of an individual who was sitting in a parked car, and his victim, um, Andre Hill, was at the entrance to a garage as the officers pulled up. Mr. Hill entered the garage and then was told to exit. And as he was exiting the garage, he was gunned down in less than 10 seconds from the arrival of uh, Officer Adam Coy and his partner there at the scene. So that's kind of the short Cliffs Notes version of how we've arrived at this point.
Yeah, I do remember we spoke about this pretty recently. Um, so, what is a dereliction of duty?
So Adam Coy is facing 4 charges right now. He's been charged with felony murder as a felony of the first degree, felonious assault as a felony of the second degree, and 2 counts of exactly that, dereliction of duty. Now, dereliction of duty is a specific code section in the Ohio Revised Code, and it says that specific acts that a law enforcement officer must do or may not intentionally fail to do, either negligently or recklessly. So, for example, a police officer can't negligently fail to serve a warrant without delay, or fail to prevent or halt the commission of an offense, or to apprehend an offender when it's within the law enforcement officer's power to do so alone or with assistance, or fail to perform any lawful duty in a criminal case or any criminal proceeding. Now, it also applies to detention facilities, including the prohibition against negligently allowing the facility to become littered or unsanitary, failing to provide adequate food, clothing, bedding, shelter, and medical attention, or failing to control an unruly prisoner, or failure to prevent rather intimidation or physical harm to a prisoner or another person. Now, these, as well as a whole variety of other acts, are described in Revised Code 292144, and they define this specific law that he's charged with. What we're likely looking at here is his failure to provide medical assistance after he shot Andre Hill, and possibly something as well associated with the behavior of shooting Andre Hill in the first place. Now, Adam Coy's attorney at his bond hearing provided a brief statement and noted that the grand jury had returned a no bill, returned no charges with relation to purposeful murder, intentional murder, or some people call it murder in the first degree. But instead charged Adam Coy with this felony murder, which means murder in the course of committing another felony. Now, he was also advocating for a special reasonable police officer standard to be used when judging Adam Coy's behavior. And I find that very interesting because police officers are the only profession that seem to get this special treatment after they kill another human being. So his attorney is strongly advocating for this special treatment in Adam Coy's case.
I mean, it sounds like it. It sounds like he's going to get away with this. And, being trigger happy is never a good situation when you're a cop. And we've seen this over and over again. Does Marcy's law apply to Andre Hill's family?
So Marcy's law changed the definition of a victim from the definition of 2930. The victim is now defined as any person against whom a criminal act is committed directly, or anybody who's directly and proximately harmed by a criminal offense. Now, the phrase direct and proximate, what does that mean? That's some legalese. So what that means is people that are closest to the harm. And in the case of the murder of Andre Hill, that would include his daughter who lived in the home, and other very close family members that have maybe a financial dependence on him or a very close relationship with him. Now, she in particular, Andre Hill's daughter, will be able to exercise these rights on her own behalf through an advocate, like a family member, or through an attorney. And this is one of those areas, Erica, that I think is really abused by prosecutors these days. Because when they want to hide behind Marcy's law and force a very harsh penalty on somebody who might not deserve it, then they use Marcy's law and they hide behind it and they say, well, the victim wants this, the victim, the victim, the victim. But what we also see time and time again is victims who don't want consequences. And the prosecutor says, well, I have to use my independent judgment in this situation. So I will say yet again, Erica, that Marcy's law was one of the worst decisions that the people of Ohio have ever made in referendums. And this amendment to our Constitution, in my opinion, is the worst thing that has happened to the Ohio Constitution in a very long time, and kind of an embarrassment to Ohio that this has come through. Specifically, this law is supposed to protect the right of victims to be treated with respect, fairness, and dignity. Now, if a prosecutor isn't doing that, then I think there's something wrong with the prosecutor, and we don't need an Ohio constitutional amendment to protect that. It creates a constitutional right for the victim to have information about their rights and services. And again, these are administrative code type things. If the prosecutor's office isn't fulfilling their duties, that needs to be handled at that level. We don't need a constitutional amendment for this. It includes the right to notification in a timely manner of the proceedings and developments in the case, as well as the right to be notified of all changes to an offender's status, meaning if an offender is in jail or released from jail, on parole or released from parole, they have to be informed of all of this. The right to be present at court proceedings and provide input into the prosecutor's decisions with regards to plea bargaining, and the right to be heard at plea hearings and sentencing hearings, or any other process that may grant an offender's release. Last and not least, the right to restitution. Now, as I said before, Erica, all of this can be covered by the Ohio Revised Code and was previously either covered by the Ohio Revised Code or the Ohio Administrative Code. So why we now have a constitutional amendment about this, I can't begin to understand. But yes, to answer your question directly, Marcy's law does apply to Andre Hill's family and particularly his daughter. I hope that she receives the respect and fairness and dignity that she deserves, regardless of the prosecutor's office's constitutional obligation to give that to her.
Absolutely. And we wish them the best of luck.
And with that, Erica, we will now turn to segment 2 of our show today. Now, I have talked to hundreds of people who are in the investigative stage of sexual assault allegations. And the one thing that I've heard over and over again is that other attorneys had turned them away as they looked for the assistance of counsel. They've been told over and over again, wait until you're charged, or something of the similar nature, and left in the dark about opportunities that exist in this critical stage. Our holistic approach to criminal defense in the pre-indictment or pre-charge stage of the investigative case is leading to success over and over again and changing our clients' lives for the better. How wonderful would it be, Erica, to have the relief of knowing that criminal charges that were once bearing down on you are not going to issue. Your name is not going to be raked through the mud in the local newspaper. You're not going to be indicted and incarcerated and photographed and printed and had your DNA loaded to a public state-run database.
I mean, I think it would be a huge relief.
And if you could avoid all of that, why wouldn't you?
Exactly. I mean, I know that people don't think that they need an attorney until they're charged with something, but an ounce of prevention is worth a pound of cure. You've also discussed on a lot of cases how, if somebody is charged with something and they decide not to fight it, or I think they think it's not a big deal this time, how it actually does ruin their life in a lot of ways that they didn't even think about, like their job, family, sometimes being able to see their kids. It's just, the list goes on and on. So fighting these things before they even get going can really make a huge difference in the rest of your life and the life of your family.
That's exactly true, Erica. There are so many collateral consequences from not being convicted of a sexual assault crime, but merely being accused of a sexual assault crime. And by engaging an attorney early on in this process, as soon as you know an accusation has been made against you, a lot of that harm can be prevented.
Yeah, and I think you're right. It's just so damaging to your career and your, what's the word I'm looking for? Oh, sorry. So it's so damaging to your reputation. And even if you get it fixed later, a lot of times the damage is just done.
That's absolutely true. The knowledge that an accusation has been made and that an investigation is ongoing is really a rare gift in the criminal process. And whether and how to provide a statement, to submit to a polygraph, or to give a DNA or other physical specimen sample to the police can be a key determination as to whether charges are ever issued against an accused person. The introduction of additional and intentional contextual evidence to the police's investigation really helps them get a full understanding of the circumstances and has repeatedly resulted in no charges issuing against our clients in dozens of cases. In the circumstances that charges are considered, participation from the outset can result in an invitation to testify at grand jury, or if charges ultimately issue, a summons rather than a warrant for appearance on a complaint or the indictment in an allegation of sexual misconduct. What we're talking about here is being engaged in the process very early on at both a law enforcement and a prosecutor's office level. And the trust that builds, the faith that the prosecutor's office is going to have that you're going to show up to court, that you're not going to go on the run. And the credibility that it builds throughout the process with the police, with the prosecutors, with the judge, and ultimately with the jury. In all of these circumstances, the accused person taking charge of that narrative in a legally informed and a strategic way can be invaluable, regardless of what direction these cases ultimately take.
I mean, I absolutely agree with you. And I'm a big supporter of having an attorney, having any expert take over the job that they're supposed to do. I mean, you don't want to try to do something that you've never done before because you think it's not a big deal yet, when a criminal accusation is a very, very big deal. So speaking of that, what are the legal rights um, that you can have during a police investigation that a lawyer might be able to protect you with?
So until a criminal action is filed, no one is under any obligation to cooperate with a police officer's request for information or evidence. That means the target of the investigation has no obligation. That means other family members have no obligation. Nobody. Police are just like any other person. And if you don't want to talk to them, you can say, I don't want to talk to you. Now, if a warrant issues, it doesn't necessarily mean that charges have issued or are coming. Search warrants can be based on reasonable cause, which is a much lower standard than what's necessary to have charges come out. And that reasonable cause is just to believe that an offense is happening, happened, or is ongoing. Regardless, if a warrant is in place, that's your cue to retain an attorney as soon as possible. Now, our recommendation is that on your first contact with an authority questioning you about sexual assault allegations, be that a supervisor at work, a police officer, or a school principal or other official at school, you should immediately exercise your right to remain silent and hire an attorney. Don't be fooled into believing that if you tell the truth or cooperate, nothing bad will happen. If you've been accused of sexual misconduct, get an attorney and speak only through that attorney. The way that the story gets manipulated, the failure to properly record and track statements that you make, the ability to manipulate what you're saying and manipulate your feelings in the moment is so high at this early stage in the investigation. Having somebody that's going to take a reasoned, logical approach to getting your story told and told in such a way that it can be supported by evidence is critically important, so that the first version of your defense is the same version that you have at the conclusion of your case. And whether that's when you're talking to a law enforcement officer, talking to a prosecutor, or talking to a jury.
I mean, I think that's really great to know, because so many people do not take the right action when time is of the essence. So let's discuss a little more about this holistic criminal defense influence. How does it help your pre-indictment defense strategy? And you talk about holistic criminal defense a lot, and I'm not sure that everybody even knows what that is, but you might want to throw that in the answer to this question. I just love hearing about it.
Thank you. I appreciate that cue, Erica. So, holistic criminal defense is something that we coined and we started doing about 10, 15 years ago. And what we saw was that time and time again, our clients were benefiting from our assistance in the courtroom, but they were benefiting almost equally through our assistance outside of the courtroom. So, talking to our clients about their strengths and weaknesses, connecting them with individual services, pointing them in the right direction, keeping them motivated, even giving people simple things like meditation apps and particular YouTube videos and websites to read over and over again, not only helped our clients' cases in the courtroom, but made them feel better about the whole process and really prevented future, antisocial behavior, negative consequences throughout the whole process. So when we identified that benefit that we were giving to people, back then, we started making sure that we incorporated that into all of our cases, and we started making that a really critical point to every single person that we help. We make sure that we touch on that mental health basis. We make sure that we touch on those available services to them. Every single one of our clients gets a whole packet of information about the importance of mindfulness practice, about the importance of meditation and tools to engage in the meditative process. In these particular circumstances, when we're talking about pre-indictment sexual assault allegations, we have to first look at the circumstances of the allegations, and we provide appropriate referrals on that basis. So we do things like refer for individual therapy, anger management, parenting classes, sex offender risk assessments, even things, even more intense like cognitive behavioral therapy, or, something as maybe outside the box as life coaching. In some cases, inpatient or outpatient drug or alcohol treatment becomes important. And of course, frequently crisis intervention by a licensed and certified interventionist is frequently a tool that we need to use because of the nature of these allegations. We want to make sure that our clients are in the best mental state, because what they're going to be going through over the coming weeks and months is some of the most intense stress that they're ever going to experience in their entire life. Now, our unique intake and investigative process includes self-reflection by the client and provides insight into the circumstances and the possible causes and ways to avoid these sorts of situations in the future. Whether the allegation is true or the allegation is false, there's always room for improvement, and especially so maybe in the situations where the allegations are false. The behavior that made somebody that upset with you, that made somebody so mad at you that they would make a false allegation of sexual assault, is behavior that likely needs to be addressed and changed and made better in the future. Now, in addition to addressing the needs of our clients, we aggressively and intentionally investigate and create what we call an innocence packet. Now, that information is our first evidence disclosure. And whether that goes to the police or whether it goes to the prosecutor, it serves as the foundation of our ultimate defense at trial, should the need come to it. We collect, preserve, and submit for expert review physical, digital, and forensic evidence to our network of expert laboratories, computer specialists, forensic psychologists, and mental health professionals. What we're doing here is we're creating our own investigation, because what we found out time and time again is that police officers, they don't do the objective, fair and balanced investigation that they're supposed to do. They do a one-sided, let's figure out how we can convict this guy. We're only going to collect evidence of guilt-based investigation. And by doing this objective investigation, gathering evidence of innocence and turning it over to the police or the prosecutor early on in the process, the police and the prosecutor, be it in front of the judge or in front of the jury at some point, will have to admit that they received and ultimately ignored this evidence of innocence, which just highlights even more how biased their investigation was from the very beginning.
Well, I mean, I agree with you, and I'm glad that you are watching out for that. And the things that you say about the holistic criminal defense, it just really show how your firm stands out from the rest and how you really truly care about your clients. And I think that's very special, because that is not synonymous with how people feel about trial attorneys.
Well, I appreciate you saying that. And, to be really candid, Erica, the clients that hire us and we are successful with in a pre-indictment basis, the value of those cases to us is anywhere between half and a third, and sometimes even just a quarter of what we could receive in legal fees for cases that get indicted, go to a pre-trial, and ultimately go to trial. So we're really cutting ourselves off at the financial knees by doing this, but for our clients, the benefit is enormous. No indictment, no newspaper articles, no family upheaval. And we find that the benefit that we provide them really comes back to us. Maybe it's karma, maybe we're just, we're doing something good, and the good comes back to us. Because what we find is that clients in these situations, they really appreciate it, and they share that appreciation.
Yeah, no, I absolutely agree with you, and it's one of the things that I admire about you and the people that work in your firm. Everyone there is caring, and you are doing a lot for humankind. So let's go to the next question, because I found this very interesting. I had never really thought about, well, we're trying to do something preemptive here when you talk to somebody before they're even formally charged or formally accused. So, do charges have to actually be filed for someone to be found innocent of a sexual assault accusation?
Absolutely not. In order to be acquitted at trial or through a complete dismissal of charges, charges do have to issue. But each case is really dependent on its individual factual circumstances. In a general sense, we will continue to monitor for charges or indictments, including following up with the police or the prosecuting and attorneys for an appropriate period of time following the investigation. Now, in some situations, we're looking at 3 months, 6 months, a year, and ultimately, we will continue to monitor court dockets for the entirety of the statute of limitations period for each each case as applicable. Sometimes we receive the clarity of a no bill, a decision from the grand jury, the body that decides whether there's enough evidence to even charge somebody, or a letter of declination from a prosecutor's office. Other times, the question of whether charges are going to be issued lingers until the end of the statute of limitations. Occasionally, we even have a police officer say, look, I've got to take this over to the prosecutor's office per protocol, but what I'm telling you is, I don't think charges need to issue here. So, we'll see what happens. What we offer ultimately is the peace of mind to control what can be controlled and prepare for whatever course of events do come to play out. It's something that we're passionate about in our practice and we advocate for strenuously.
I know you do. And you also keep everything so down to earth. And I know that a lot of times when someone is even accused and they're not guilty, they have to come in and talk to you, they feel embarrassed. And that's really one of the things that I think that you guys do well is as well, is because you have someone come in, they're just a person, you know, bad things happen to good people, and you are there to listen to it and give them their best options and offer some of the best strategies to help them out of their predicament.
Erica, that is critical to the way that we practice criminal defense, um, especially as we focus our practice on sexual assault defense. We're talking about sensitive topics. Talking about sex, even in the best of situations, is awkward, difficult for a lot of people, and frequently embarrassing. When you're talking about allegations of sexual assault, it's even more so. And I have found that taking a very direct approach to these conversations, being very candid, using appropriate language, talking about the penis, talking about the vagina, and saying these words aren't foul language. This is straightforward. And just really addressing things head on is the best way to make people comfortable with sharing their story. And sharing your story is by far the most important thing that any client can do with their attorney. And if you don't trust your attorney enough to share your story with them, to share your truth with them, you've really got to consider whether that's the appropriate attorney for you.
Absolutely. And I'm really glad that your clients have you. And I would strongly encourage anyone that is having an issue in this area or knows someone that could use some advice to definitely give the law office of Brian Jones a call, because they will take care of you. They keep up on all the latest with the laws. They have the best strategies, and they treat you like you're a human. They're very empathetic, and that's not something that you can find everywhere. It's quite unique and special. And thank you so much for allowing me to come on and hear about these issues and talk through some of them.
Well, I appreciate you joining me in this discussion, Erica, and I appreciate everybody who takes the time to listen to our show each week. And remember that if you want to become more informed about the latest hot topics in the law, police, and government accountability, or false allegations defense, everything you need to know about your constitutional and civil rights, Check out the law office of brianjones.com or find us on Facebook at facebook.com/Central Ohio Criminal Defense. You can find us on Twitter, Instagram, and TikTok at TLOBJ, and look for our hashtags no walk, no talk, and no blow. We'll be back next week with a Sui Generis perspective on the next big thing in civil rights and criminal injustice system news, as well as a discussion of your rights in an administrative or workplace sexual assault misconduct investigation. Erica, my grandfather always told me when we parted ways, hey kid, don't do anything I wouldn't do. And to that, when I part ways with my friends, I add, if you do and you get caught, call me. I'll defend your rights as I'd want mine defended.